My name is David Pearson, and I am a board member for the Contra Costa County Bar Association, and I'd like to welcome you to your law practice roadmap. This is our presentation number 8, Alternative Practices of Law Inside the Law. And I'd like to thank our sponsors who've been sponsoring so far all 8 of our presentations: DLC Consulting Services, LawPay, and Thomson Reuters. I'd also like to make sure everybody is aware that the bar is still holding the MCLE Spectacular. It will be entirely virtual. We've sent out all of the registration information, and so we look forward to seeing a large turnout virtually for the MCLE Spectacular this year. So with that, I'm going to turn it over to Kate Mignani to get the presentation started.
Great, thank you, David. I am Kate Mignani. I am an attorney with Edrington, Schirmer, and Murphy law firm in Pleasant Hill, and I am on the education committee of the Contra Costa County Bar Association. And it is my absolute pleasure to introduce our panelists tonight, who will be talking about alternative practices of law. We have Commissioner Christine Donovan. She is a certified family law specialist and a commissioner in Contra Costa County. She deals with child support and related matters involving Department of Child Support Services. We also have Juliet Jonas, who is associate counsel in the Business and Operations and Law Department, acronym BOLD, by the way, at Robert Half International. And we have Mark LeHocky. Mark is a mediator with ADR Services, and Matt Malone, Chief Counsel with Contra Costa Superior Court. And so everyone is familiar with how the rest of the presentation will go. We are going to hear from each one of our panelists, one by one. You will hear about how they arrived at their alternative practice of law and a little bit about what that entails in their current jobs. After that, we will have a time of question and answers with our panelists. Some of the questions that I will be asking that we have prepared ahead of time, and then there will be a time for you attendees to be able to ask questions. And if I understand correctly, I think you can go ahead and put your questions in the chat bar, and David Pearson will be monitoring those, and we will answer those questions at the end. So with that, we're going to start with Commissioner Christine Donovan. She received a bachelor's degree with highest honors from UC Davis and earned her JD from Santa Clara University School of Law, where, among other things, she was a recipient of the Herman Wildman Social Justice Writing Award. Very impressed by that. She's a published author. Just one of her articles appeared in the Harvard Women's Law Journal entitled "Invisible Victims: Holding the Educational System Liable for Teen Dating Violence at School." She was a research attorney for Solano County Superior Court and a faculty member at various entities, including an adjunct professor at John F. Kennedy University, where I was privileged to be one of her students. So with that, Commissioner Donovan, we would love to hear your story. Although I think you'll need to be off mute.
Yep.
There we go.
So from my perspective, though, Kate had to suffer through my bad jokes and really horrible hypos all for 15 weeks of wills and trusts. So yeah, kudos. But thank you all for having me as a panelist. I very much appreciate the opportunity to participate and share what my path was to an alternative practice. I actually started out as probably a more traditional attorney. I was in private practice for 4 years in Sacramento, where I served as an associate attorney doing family law with a well-known firm in Sacramento, Bartholomew, Woznicki, and Molinaro. And so those 4 years were really helpful for me. One, I was a baby lawyer, so I had to learn from the ground up what it was like to practice law. I had had some experience prior to that working as a law clerk for a family firm in San Jose. As you know, I went to Santa Clara University Law School, so I was able to clerk for a family law firm there. And I also clerked with a judge my second year, I think it was. And my third and final year of law school, I did a 1 semester long judicial externship. So I had a lot of exposure to the court system, and I discovered I really like working in the court system. But it's unusual to go work for the court system as an attorney, especially one straight out of law school. Now it's not impossible, but it's unusual. I did 4 years in private practice where I really enjoyed the subject matter of family law. I had some clients that were awesome. I had some clients that were terrible. And so, but one thing that I kept coming back to is that there were 2 things that being in private practice and representing clients kind of prevented me from doing. One was being able to pull back and look at it from a more neutral stance. I had to take an advocacy position on behalf of a client. Even if I thought the position was weak, I still had to go in and represent my client's interests. And I always did the best that I could. But sometimes, you know, your heart's not quite in it. And sometimes the other thing that I felt I wasn't able to do was to focus on writing. And writing is something that I'm pretty decent at. And when you're in private practice, there's just, your clients don't want to pay you $250 an hour to write Gone with the Wind. It's just not something that they're willing to do. So you have to manage your time, and you don't really have the ability to dive into some interesting legal theories and questions that arise in your clients' cases. In 2007, Solano County Superior offered me a position of a family law research attorney. It was actually a position that they created as a 1-year limited term contract, and they offered it to me, and I just jumped at the chance. And within a couple of months, it was converted over to a permanent position. So I stayed with them for 12 years. And in that time I did family law primarily, but about a year into my stay there, they asked me if I'd be willing to take on probate as well, because there was not a dedicated probate research attorney. So I said, yes, I liked wills and trusts. It was an area of interest to me. So I said, sure. And so I took it on. So for 11 years, I wore 2 hats. I had the family law research attorney hat and the probate research attorney hat. I also wore the hat for handling local rules. I worked with the facilitators in the clerk's offices on issues that came up with filings or fees or forms. Can we accept this for filing? Is this okay? Kind of as a general go-to person for a lot of different things. And I really, really, really enjoyed that. And it was a tough decision to leave, but only the siren call of becoming a judicial officer could have persuaded me to leave, and that's what happened. Contra Costa offered me the family law position of being a DCSS commissioner in April 2019. So I accepted that. 18 months ago, time flies. It's been incredible. It's been an incredible ride of having to deal with budget cuts and then 2.5 months of court closure and trying to get through the backlog and dealing with the aftermath of that. But I wouldn't trade it for anything. I really, really enjoy being a neutral, being able to try to do what I can to help solve problems for the families that arise in front of me. I make decisions that are not universally popular. I am sure that I'm probably burned in effigy in someone's home or voodoo dolls or what have you, but I do the best that I can. And I like the fact that I'm able to come back to my roots, which is to be a neutral, which is to be able to look at those problems. And if I have to be able to do the deep dive and do the research and crank out a well thought out, researched, well-written decision. So I'm just incredibly grateful that I've had that opportunity, and what a ride. Kate, is this where you want us to go into the questions, or is that later? Or you're muted.
I think we'll go into questions a little bit later, although that is a good segue for me to remind those who are attending that if you have questions for our panelists, go ahead and put them in the chat bar, and David Pearson will be monitoring those, and we will circle back to those questions at the end of our presentation.
I think there were some prepared questions as well. Did you want us to hold off on those?
Yes, I think what we're going to do is we'll have each panelist speak, and then we'll answer those 4 questions all together.
All right, great. Thank you.
All right, thank you. And I want everyone to know that that Commissioner Donovan's sense of humor is excellent, and we did laugh every single week, and she and I have a shared love for Princess Bride. So good times for sure. All right, next up we have Juliet Jonas. Juliet is Associate Counsel in the Business Operations and Law Department at Robert Half International, which was founded in 1948. It is the world's first and largest specialized staffing firm with 7 distinct divisions operating out of 300 wholly owned branch offices located throughout North America, South America, Europe, and the Asia Pacific region, and even in the Middle East. After graduating from UC Davis in 2007, Juliet worked at Archer Norris in Walnut Creek. After leaving the law firm life, she worked on a contract basis for some local law firms, including the one I work for right now. We miss you, Juliet. In 2017, Juliet became a full-time faculty member in the Legal Studies Department, Legal Studies program at John F. Kennedy University, where I was very fortunate to have her as my professor. Life-changing experience. That's where I learned Iraq. And a year ago, Juliet started her current position at Robert Half. And so Juliet, if you could take it from here, and we will listen to your journey to where you are now.
That's great, Kate. Thank you. I think that I might have given you a little bit too detailed description, because that kind of covers it all. But to put a little bit of color, I found myself, I played volleyball in college. And so after college, I did the whole, I think I'm going to go around here, and just kind of wandered around for a while, and eventually found myself in need of an actual job. And so in 2003, I moved back to California and started going to law school in 2004. And I had never had any legal experience except for my dad was an attorney. And he had suggested several times that I should go into the law, and I just never really pictured it until I was out there working as a college coach in Division I volleyball, making under $30,000 a year, and realized I needed to kind of grow up. And so then I graduated from UC Davis in 2007. In the booming economy that was 2007. And while it's nothing like the economy right now, it certainly was not an easy time to get a job. For those who remember those glorious years, it was a very humbling experience to have to try to find a job graduating. And so then from 2007 through 2011, I worked in civil litigation, and kind of found my way to doing different actions. At that time, foreclosure was a really big issue in residential real property. And so I found my way onto what we would call, because we were representing the defendants, foreclosure avoidance actions. I'm sure that the plaintiff's counsel called it something different. But I got a lot of experience with motion writing, and it's really challenging as a new lawyer to find a law firm, and I think Commissioner Donovan talked about this, to find a law firm who's willing to take on you as a new lawyer. There's a big learning curve, as we all know, we've all gone through, from law school to the actual practice of law. And I knew that I wanted to stay in the East Bay, and so needed to find a big enough law firm who would be willing to take that on. So I really did have a great experience working in this mid-sized law firm. I loved working there. And then when it came time for me to kind of start the next phase of my life and start a family, I came back and tried to explore options for not working, 90 hours a week. It wasn't 90 hours a week. It was a lot. And working in a way that would allow me to ensure that I wouldn't miss my kid's birthday party or anything. And it just came down to there not really being that path at that time. So I left there, but had made enough relationships with folks that I was able to work on a contract basis, and mostly was focused on, again, drafting motions, which I really enjoyed, and also kind of some trial prep projects. So I did that until around 2015, until because of a connection that I had from working at the law firm, was recommended to the dean, well, the current dean, but was at the time the chair of the legal studies program, to have a faculty position there. And so I worked there until 2019. That would be definitely another area that, although that's not where I currently am, where you could explore trying to use your degree in an area that is not in a law firm setting. And I had an incredible experience teaching and making those connections. It's a very different world from the litigation world, because people are generally happy to see you, at least in the beginning of the quarter. And for the most part, very open to learning. And you just have an opportunity to, as an educator, learn so much more about the law. I never understood the tenets of torts law until I had to teach it. So it was a great opportunity to develop professionally myself, in addition to a lot of the emotional fulfillment that you get out of having these adult learners who are trying to take a different path in their career. And so that was a great opportunity. Then about a year ago, almost exactly a year ago, I made the transition to working in-house at Robert Half, which owns, it has several different divisions, one of which is Robert Half Legal, where we can do either project-based or hourly work. And so my job at Robert Half is to draft those agreements for staffing. So I'm in the contracts group, and I've been here for about a year. And so there's just a lot of opportunities. And I look forward to talking more about kind of the comparison between where I am now and the law firm world once we get there.
Thank you, Juliet. That was fantastic. Next up is Mark LeHocky. Mark is a mediator with ADR Services, who previously served as general counsel at Nestle Dreyer's Grand Ice Cream Inc. That would have been a great place to work, I would imagine. And Ross Stores Inc. Prior to his general counsel days, Mark spent 20 years litigating commercial, IP, antitrust, class action, and other disputes for clients ranging from small businesses to Fortune 100 companies. He began mediating 2 decades ago when appointed by the federal court to resolve complex cases. He has since been repeatedly voted a best lawyer in America for mediation by US News Best Lawyers. And he teaches, oh, my light went off, sorry people.
It all works.
Yeah. Mark also teaches at UC Berkeley, Haas Graduate School of Business, go Bears, as well as Berkeley Law on the intersection of law, risk management, and decision-making. Okay, Mark, take it from here. Thank you so much.
Thank you, Kate. For what it's worth, I had a mediation about a week ago with about, I'm not exaggerating, 20 different participants spread about different rooms. And we were making great progress on a long, complicated case. And at 5:30, everyone, all 20 of us, got the simultaneous message from Zoom saying, by the way, we're shutting you down in 15 seconds. Things happen. We restarted. Yes, thank you for the introduction. And yes, I would like to say a lot of my career background was very, very well thought out, but in truth, a lot of it was just getting interesting phone calls and reacting to that. I started out purposely when I was still in law school, and I'll go to the risk of really dating myself. When I was back in law school, my school, Berkeley's Law School, was actually one of the sites that was given permission to beta test LexisNexis. That really makes me old to say that, but I was one of those people who could go in and play with this new technology where you could search by words. All things we take for granted, but it was a big deal back then. So in my spare time, and I'm sure violating the Lexis rules, when I was otherwise doing research, I got interested in one day doing some searching about an area of the law that interested me, and that was antitrust law. And I did some searching trying to identify law firms that had successful track records in plaintiffs' antitrust work, not defense plaintiffs' work. And lo and behold, through some digging around, I found a little firm in San Francisco that had more successes than losses when you look at all the reported decisions. And I wrote them a letter and I said, can I work for you? And they said yes, and that's where I started my career. And absolutely got thrown into everything you could imagine, being at a small firm trying to do big cases. Co-tried my first antitrust case 1 year out of law school with, of course, a senior attorney, and got a phenomenal amount of experience. Also got exposed to some really interesting work on the defense side. This is not a political statement, it's not a philosophical rant. And there's good antitrust cases, there's bad antitrust cases. Employment, IP, everything. And really enjoyed that work, and the learning experience was phenomenal. Actually, starting at a smaller firm, from my perspective, I was thrown into much more than a lot of my peers were at larger firms. That's not a criticism. Larger firms, on balance, have more developed training programs and have a lot of great benefits, but I was thrown into things. And 5, 6 years later, I actually split off and created my own firm. My firm merged, my pre-existing firm merged with a big firm, and I had enough independence in my own role and clients my own that I didn't need to do that. So I stayed small, and I litigated and was thoroughly enjoying that for about 17, 18 years, when one day I got a call from a federal judge, actually magistrate judge in the Northern District, Judge Wayne Brazil, now retired, former Contra Costa resident. And by the way, he did not call me. His deputy called and said, Judge Brazil wants to see you. I immediately reacted to that saying, oh my God, something went wrong. The judge is ordering me to show up. But it turned out nothing went wrong, at least that particular day. Rather, he asked me to get on the federal court's mediation panel and see if I could help resolve cases. And both, one professional rule, piece of advice to give everybody: when a judge asks you to do something, the typical response is yes. So I did do that, both because it was an honor to be asked, it was a good volunteer project, and told my partners in my firm, I'm going to continue to do this while I'm doing my regular job, and started to do that work. And a few years later, one of my clients, Dreyer's Ice Cream, called me and asked me to become their general counsel. Now, I had no interest up to that point in an in-house career, but I was lucky to work with an exceptional leadership team through some really fascinating things, large and small, antitrust cases, contract cases, class actions. And then one day they asked, and I said, hadn't thought about it, but it makes sense. I also politely said, now you know that I don't know anything about being an in-house attorney. And the wonderful CEO, unfortunately since passed away, said, you'll figure it out. And that's really what happened. Within a short period of time, I was thrown into a bit of everything. And when you're general counsel, regardless whether you're small or large department, you're typically responsible for everything. So it was a huge learning curve, phenomenal experience. Relatively soon, meaning a few years into that process, we also got faced with a really interesting opportunity, which was to do a merger transaction that we did with Nestle, the world's biggest food company. Now, something that's interesting and I pass along to anybody if you're thinking about in-house career any place is really the value of sorting out what you can about the culture of the company. As it turns out, Dryers, what attracted me, frankly, was you could almost say it was a little bit of a wild, wild west culture. People today would maybe analogize it with a startup culture. They were hell-bent on growth and success, and real growth and success, not anything untoward. And so we were, well before we started our merger discussions with Nestle, we were acquiring companies, small, mid-sized brand companies, distribution companies, intellectual property assets. And I was thrown into all of that. Not on my own, of course. We brought in expertise wherever we needed it. I was very, very lucky to work with so many great people at law firms, small and large. And that was a very exciting few years. And then the Nestle opportunity presented itself. And I don't have enough time to fully explain the transaction, but it turned out to be just a phenomenal, good result for our shareholders and for our workforce, which allowed us also to maintain a fair amount of autonomy for years afterwards. And the one thing that Nestle asked for in return was that we, a group of us, stay for a period of time to help steer through the transition period. For me, also phenomenal experience to then go and be part of this huge Swiss-based company. Some people would say a fairly traditional company by comparison to Dryers. That's a true statement. But it was the opportunity to work on a world level, because I got pulled into their legal leadership team from their entire world organization. Spent some time doing transactional work in Europe and spending a lot of time in world headquarters and getting to see in a relatively short period of time how different operating groups of Nestle throughout the entire world operate. It was almost what my picture would be of being at the United Nations, comparing notes with other leaders from other countries, lawyers from other countries, learning what people are doing all over the world. A lot of similarities, but some differences. And it was all just a phenomenal insight. So we worked through our merger transaction and the transition phase to follow. And then one day I got another call, and this was from the people at the Ross Dress for Less chain. And they were needing to grow their legal department. They were about the time roughly $6 billion in revenue, roughly 50,000 employees spread around the country. And their legal department consisted of a prior general counsel and one staff attorney. It was frankly hopelessly understaffed for what they were dealing with. And they were growing at an incredible rate, literally adding 5,000 new employees every year I was there, 5 years. So lots to do, lots to sort out, and a phenomenal opportunity to learn. Now, I mentioned earlier, my mediation work continued because I told the people at Dryers and people at Ross, I'm going to still do this on a pro bono basis. And they were happy to do that. And I not only did that as a volunteer basis, but my experience working as a mediator was changing my view of how you deal with most disputes. Now, I was already, by the way, mediating cases as a litigator, finding great opportunities whether you're representing plaintiffs or defendants to solve problems sooner, more efficiently. I took all of that learning to my companies and said, oh, by the way, if I'm gonna work here, I want to be able to take everything apart and put it back together. By that, I mean to look at every dispute, whether it's small or big, and say, is there a better way of getting these things resolved? Now, lo and behold, what I discovered in what I call 2.5 positions, one at Dryers, one at Ross, and one during this interim period with Nestle when they shoved another operating division under my management of all things legal, that I saw the same pattern each time. The pattern being that some disputes, there was no reason to change anything that was going on. Other disputes made absolutely no sense to be going down the path we were going on. And the reasons given were things like, well, this is what we were told by you, the client. and other times where I just looked at it and said, we don't know what we need to know to be evaluating this case. Why don't we go try and better understand the other side's position, share ours, et cetera. So I was pretty adamant about using this ADR process, mediation process, regularly and early on. And in all those three different environments, I saw the same thing happen. And we were able to basically also measure it. I won't bore you with how we did that. Measure it economically. And we were able to show we are much more efficient as a company. We're saving not only money, but people's time, which is more valuable than money in many cases. And that just turned the tide for me. So after about 12 years in the GC world, about 8 years ago, I retired from that world just so I could spend time focusing on ADR work, both as a mediator primarily and as an arbitrator, and also teaching. As Kate said, I teach at Berkeley Law and currently at the business school. I'm two halves of the same coin. Basically, why does the legal system work well in some situations and why does it become an utter disaster in other situations? And there's some highlights and lowlights to all of that, which just fascinate me. And the whole process, I think as Juliet was saying also, being involved in teaching, it forces you to stay current, forces you to stay fresh. And I love the engagement with all the students I get a chance to work with.
Fantastic. Mark, that was fascinating. Thank you so much for sharing that with us. And for those of you who are watching, you, as part of your handouts, you will receive a number of articles written by Mark that I think you will find equally as fascinating. So thank you again, Mark. Really appreciate that. And last but not least, we have Matt Malone, Chief Counsel with Contra Costa Superior Court. Hey, Mark. Hey, Matt.
How are you?
Good. So Matt graduated from USC Law School in 2002 and was in private practice focusing on business litigation, construction defect litigation, consumer class action, and appeals. You know, just specializing on a few things. Excuse me, from 2005 to 2013, he practiced at Birding & Weil, LLP, first as an associate and then as partner. Thereafter, Matt was of counsel and later partner at Ram, Olson, Cheragino, and Kopczynski. I said that correctly?
Yep.
Rock Law for short, and for ease of pronunciation. While in the early part of his counsel period at Rock, he took a position as a contract research attorney for the Contra Costa Superior Court, initially with financial services and the financial services unit, where he oversaw the court's process for achievement of over 2 decades of unclaimed trust funds. I can't imagine what that must have been like. And thereafter, for law and motion matters in the civil division. In 2018, he left private practice to become a full-time research attorney for the civil division. And roughly 7 months later, in May of 2019, he became Director of Compliance and Communications. And that position was later renamed Chief Counsel, the position he is in now. So with that, Matt, take it away.
Thank you, Kate, and thanks everybody who's attending. Yeah, that as Kate said, my background until very, very recently has been in private practice. So it's only within the last 2 years that I've sort of full-time switched over into a quote alternative career. And most of my practice had been all plaintiff side litigation. So it had been construction, it had been consumer class actions and appeals. And it was appeals, and in particularly the complex law and motion work that went into the class actions, where I started to feel the kind of pull towards legal research and writing. And another speaker had said this, and I forget who exactly, I apologize, but the opportunities for that were not as prevalent in private practice as I'd hoped. I mean, truthfully, there were a few, mostly in the class action world, but I found that was something I was enjoying much more of. So I practiced for a long time at a single firm locally, and then I when I moved to what we called Rock Law, that was individuals who'd been at the prior firm as well. And when that role started, I had the opportunity to just kind of, for a lot of reasons, one of which is moving to a plaintiff's class action firm had a risk. I wanted to have a second, it's kind of a backup thing just to kind of keep the lights on, because a lot of the plaintiff's class action work is contingency, and that we did have some hourly work on the side that we had to try to keep the lights on as well in between the contingency cases. I personally wanted to have some of that too, and that was where I started looking for opportunities. The opportunity to come to the court, it was something I applied for. It was not something that I knew anybody for. I just saw the opening out there, and I applied for it. It turned out that, unlike most of the research attorney positions that a court would have, this one was a contract position uniquely designed for someone who had done litigation, because it was focused on applying different principles in judicial council policies, et cetera, to conduct the escheatment process in a compliant way. So my eyes had to be on the risk associated with it, which, as a lot of what a litigator does. So the escheatment, I was actually hired, and we'll talk about this, I'm sure, a little bit too. This is where sort of the personal relationships kind of come into things. I was hired as a contract attorney for escheatment with another gentleman, another guy named Matt, actually. And they originally envisioned two people doing the escheatment. They also, at the same time, within about a month, had a career legal research attorney position advertised. The other Matt applied for it. I did not, because I was still at just the beginning period of my time with the Rock Law firm. And so I ended up doing all of the escheatment and designing that process for the court. And while Matt went on to be a career research attorney in civil. He was actually the first person to be director of compliance and communications. And that part of that role was to oversee the legal research attorneys. So in the few years that I was with Rock, when I was even more so feeling the pull to move to legal research, he ended up being the supervisor at the time that the opening came up, that I ended up taking in 2018 to become a full-time legal research attorney. I then, so he kept the director of compliance and communications position for a while until he ended up relocating for different reasons out of state. And I was asked by our CEO at the time, who I had also worked with in some of the escheatment processes, to take that position. And then during the COVID times, that position was renamed. So, like I said, a lot of that, a lot of that you can see has to do with, sometimes it's accidental timing, things being placed at the right moment. It's a little bit of me feeling the pull at the right moment. And then it's a lot of just taking the risk, in one case, to jump out and just apply and take a second job even while I was working, which it was tough. I mean, there were times when it was quite literally two jobs. It was a full-time job during the day, and then because a deadline would come up or a particular tentative ruling had to be drafted, it would be a long night. And then on top of that, the personal relationships that you build. And like I said, I think we'll discuss other people. We'll talk more about that too. What I do now as chief counsel, it seems to change every day. It's a little bit of a catch-all position. I am primarily responsible for advising the court on compliance, in line with the old title of Director of Compliance, with compliance with federal and state rules, judicial council policies, rules of court, etc. There are a number of duties that the rules of court assign to a chief executive officer that are then assigned down. So I have some interesting roles that have nothing to do with what I ever trained for in law school or otherwise. So for example, I am the temporary judge administrator. So I oversee the temporary judge program on behalf of the presiding judge and the CEO, which has been kind of a rough go with COVID, trying to do trainings and things like that. We're trying to get it back up and running again, but that really threw a wrench in things for a while. But that has a lot of compliance elements to it. There's a lot of rules about how often a temporary judge has to be trained, has to take training, what that training is, how the court records that, how the court makes sure its temporary judges are compliant, discipline issues, etc. I do draft policies and procedures as well as part of one of my rules, including procedures about temporary judges. And I'll say as an aside, you have to have usually quite a bit of experience, every 10 years out, under most circumstances, to be a temporary judge. But I like that program a lot in terms of if you have a kind of a feel for the adjudicatory side of things, like Commissioner Donovan had talked about, that's a way to kind of exercise that, to become part of the temporary judge program. And we have that on our website for those who qualify. And I'd encourage you to take a look at it. We do take applications, and I promise it will be up and running fully post-COVID. As we keep fighting, Another role that I have that I never would have dreamed of myself being in is public information officer for the court. So I do all of the responses to requests for court documents, public records requests. Courts are not subject to the Public Records Act, but they do have a separate rule of court, Rule 10-500, that talks about disclosure of our administrative records. It's very technical. There are a lot of exceptions. It helps to kind of have someone with legal training look at it. It feels like discovery sometimes, but it's much different in its own way. But again, having that experience helps, right? It translates, which is also something that I think sometimes I've been surprised about. I've been surprised about how I've been assigned roles that may or may not have had a lawyer attached to them, but how my particular training from before has informed the work that I do there. So even if you think, you're not particularly ideally qualified, if you look down the list of things people are looking for a particular position in an alternative field, you may be more qualified than you think, and you may have more experience that translates than you think. That has been the most interesting part. Well, I don't know about the most interesting. Probably the most challenging part of my job is public information officer, because I do all of the public interfacing, from general questions that we get to media requests, coordinating interviews, drafting. I draft all of our press releases and public statements that aren't straight up interviews. So that has a lot of challenge to it, because what I'm drafting is on behalf of the court, and so you have to, there's a certain difficulty and a certain art to that. That is not something I've ever learned in law school, and definitely not something I've learned in practice, except in as much as I think a part of it, how you relate to people is developed in client contacts. I can look back on my client contacts and say, how I managed people back then is sometimes how I deal with people in the public information role. But we are, unlike the attorney to client relationship, the court has specific obligations to the public, so that the standards are a little bit different. But anyway, that's been an interesting part of the role. I do supervise all of the legal research attorneys, civil, criminal, and probate. So I've had to pick up, and I actually did this a little bit when I was a contract attorney. I just randomly picked up a criminal matter because there was an overload, and I didn't have the confidence that I would have loved to have had if it were a civil matter, but the opportunity came up, and so I kind of jumped on it, and that gave me a little criminal experience, which now has been quite beneficial. I also do now supervise probate investigators and examiners. That's a recent change. And then I do the local rules, the judicial council compliance, that sort of thing. So it's, the role is kind of, and then I kind of become a resource for our managers and our other directors when things come up that they just sometimes don't know what to do with and just need a second opinion on. I get a lot of those questions as well. So that's my background. I look forward to talking more about it and about the what I've learned. Again, I am very recently transitioning to outside of private practice, so it's it's a new world to me.
Wow, thank you, Matt. That was so interesting. You wear so many hats, right? I see your title as, you know, Chief Counsel of Contra Costa Superior Court, and you know, it's just impressive. But
Thank you.
but who knew that all of that was involved?
Sometimes
So,
even I don't.
well, thank you for serving in all those roles. That's something that's really interesting to learn. So, all right. So I think we have all of our panelists back. So thank you to each one of you, Christine, Juliet, Mark, and Matt. I learned a lot. This is very interesting, and I'm sure our attendees are learning a lot as well. So we are now going to transition into a time of question and answer. And just one more reminder before we go into our prepared questions, that for those of you who are watching, if you want to ask questions of our panelists, and it can be a general question to all of them, or you can direct a specific question to a specific panelist, please do so in the chat box, and David Pearson will be monitoring those, and we will get to those at the end of our program. So what I would like to do now, panelists, is ask you, and we'll go in reverse order in answering. So Matt, I know you just finished talking, but we're going to start with you. So the question for the four of you is, what are the advantages that you see in the alternative practice of law that differ from the traditional attorney role? So Matt, what do you see as some of the advantages?
I get to be the person who first says no billing requirement, right?
Yes.
That's a big one. Although you know, I'll be honest, it was not as hard to bill in a plaintiff side class action firm as it would be and when I did bill for the defense work that I did, or for private clients who were not class cases. So I had it a little bit easier. Not much though, because at the end of the day, you still have to answer for the billing. So, you know, I was doing it just like I would normally do, but I didn't necessarily have an individual private client checking, you know, 0.1s here and there. But I don't miss that in any respect. And I also I think that but instead of just sort of the know this, know that, because there are a bunch of those that I could answer. I like the public service element of what I do right now. I like it a lot. I find it fulfilling in a much different way than there are times when I did work for clients and I really felt fulfilled by it. I get that feeling much more now than I did because I just get it's kind of on a daily basis instead of a particular client. The other advantage I'd say, and this might be a disadvantage, I might answer it there too. No day is alike, and it's chaos because it's just. There are a lot of issues coming at the court. We are a public-facing, public-serving institution. Anybody and everybody is welcome, you know, in the sense of we are a service to everybody. So you get a lot of, or I get a lot of questions that I would have never thought I was going to get, you know, and have to answer a lot of things that I didn't expect. So those are the advantages from my perspective.
Great, thank you. And I do think that billing is probably going to come up with other panelists, but I do think that there are different aspects of why that is an advantage. So you didn't really steal anyone's answer.
Okay,
So.
good.
So thank you, Matt. How about you, Mark?
Well,
what do you see as some of the advantages in the alternative practice?
Well, I sort of went the opposite direction. I went from 12 years of not billing to now billing, but it's different. So for me, one of the great challenges was actually getting a little bit of a break from a 24/7 life, both during my litigation days and my general counsel days. It could be very 24/7. I thought it would be different going in-house. That was not the reason I went in-house. But I thought litigation's mostly about people on the other side trying to mess with you and your schedule and your life. But when you're in-house, depending upon your position in the company, you are subject to getting phone calls day and night from CEOs, from board chairmen, from other executives, and you've got to be responsive. And while I wanted to on many occasions say, this can wait till Monday, you rarely can say that depending on who's calling you. So anyway, doing ADR work, you have more control. I won't say it's perfect. When we used to be able to get on airplanes and take vacations, even as a full-time neutral, I'd still get periodic calls. People need to talk to you now. But it's dramatically different. So that's an advantage. I mean, the biggest advantage for me personally is with no planning, as I mentioned about the whole career path thing. What I love about this work for me is it's the opportunity to channel everything. Having been a plaintiff's attorney, having done defense work, having been a client, having been a general counsel, and I also do volunteer work as a judge and an arbitrator. It's really great to pull all that together and say, look, I understand your position. I understand your position. This is what I'd be thinking about. The fun part when I get my mediation briefs or arbitration matters is I read one party's brief before I read the other brief. I generally can predict what's going to be in it from just having done all that kind of stuff. Those are the advantages. There are many other ones, but having a little more control on life and schedules is a big deal.
That's fantastic. Those are great advantages. Thank you, Mark. How about you, Juliet? What advantages do you see?
Well, I have a huge list of advantages, but I don't want to give the impression that I didn't enjoy working in a law firm environment, because the collegial environment and kind of the synthesis that happens, synergy that happens. Now I can't work after 5 o'clock because I never have to. So my brain is not working, but the synergy that happens where you can just go into, somebody else's office and kind of brainstorm and come up with this new theory and all of that sort of great minds together, and being able to have all of that, when you're with a bunch of lawyers, they get all of your silly law jokes, and they, you just kind of feel like, oh, I'm not so weird. But then again, that's one of the pluses that I put about working in-house, is that you get to rub elbows with the normals, and you get to see like, oh, not everybody is watching the Senate hearings nonstop. There's other things going on in the world. And I think getting that perspective is a huge benefit when you move into the corporate world as compared to being in the law firm. For me, another benefit, and not anything negative against the folks who are managing partners at law firms, is that the people leading corporations have a motivation to lead in a way that is very different from how I think a lawyer would naturally lead. We, as lawyers, generally maybe don't have those same focuses and cares about the person's emotional well-being and how are you doing with balancing work and life. And that just was never even a conversation that I ever had with any partner at any point when I was in the law firm. But working in the corporate world, and Mark is right on that you have to get an idea of a corporation's culture before you go in, because I really have only worked at one corporation, and they are hugely in tune with folks' emotional development and professional development. And I mean, during this time, we're doing monthly surveys so that they can check in and see, how everyone is doing emotionally, which when would that ever come up in a law firm environment? They're very invested in our professional development. So I've been there a year and I've just been promoted. And so they really try to tap into, and again, it has to be a corporation that matches what you are seeking and where you would fit. But where I am, they really are invested in growing who is currently here. And to find a corporation that cares so much to be honest, it's a little disconcerting. And I wouldn't have believed any of these things that I've experienced if I didn't know people who were here before me. So the folks who I knew from my former law firm could tell me about it, because otherwise I would be like, well, let me just try to get the real story. You know, when you're at a law firm and they tell you, oh, the billable hours is 2,000 a year, and you're like, well, what is it really? You know, and so being able to work somewhere where you're not the moneymaker is a lot less pressure too. I remember feeling like it was sort of like you just are a cog and you need to work as much as you possibly can, because every single minute that you're working, the firm is making more money, the partners are making more money. And I understand that as a business model. But where I am now, my whole purpose is to try to make a deal go through and to be flexible, and so that we can still minimize risk for my employer, but also make the deal go through. So it's a lot more collaborative, which is the opposite of, although it sounds like Mark was a different type of litigator, which is amazing to know that there are collaborative minded litigators, but generally I didn't find that was a quality that was very common in litigators. But being able to use those skills in terms of just trying to get it done and trying to do it in a way that keeps and maintains that relationship with the client. You can't burn bridges like you can in litigation sometimes. And so being at a company where I'm able to kind of spread those collaborative skill sets is great. The other thing is, and again, this just depends on what corporation you're at, but I have never, since I started practicing in 2007, had an actual vacation, like what a normal would consider a vacation. Where I am now has a very, very strong encouragement of boundaries. And we have a system when you're out of the office that all of your work is routed to other folks on your team. And the same happens when our team members are out. You don't come back to a desk full of urgent matters, and they really do emphasize you taking a true vacation. So in September, I had my first true vacation where I was debating, do I even need to bring my laptop? And it felt very bizarre to not bring my laptop and to not check my email every 20 minutes or even to respond to emails. And maybe it's the level that you were, Mark, being general counsel, but as a counsel, I don't get emails after 5 o'clock. I don't get emails on the weekends. And if I do, it is not expected that I would respond to them. And in the beginning, when I would respond, it would just be met with confusion of like, well, are you wanting me to respond too? Because it's my weekend. So it's a really unique, I think, company, but there's a lot of advantages to moving outside of the law firm environment.
Fantastic. And can I just say, I'm not surprised that you were promoted a year in. It does not surprise me a bit.
It's the same situation that Commissioner Donovan was talking about, that Matt talked about, Mark talked about. Like, that was the main commonality that I've heard all of us say, is you come upon these opportunities, and even though sometimes you feel like, well, I'm not ready to do that, it's like, you know, you got to take advantage of it, and you're never going to regret the opportunity that you took, you know. And yeah, so that's what this was, is a chance to move to a different group where I didn't quite know that I was ready, but you know, I guess they feel like I am.
Yes, that's great. And I like how you refer to people as the normals. So they're not talking about proximate cause in their everyday language, right?
Not on purpose.
Not on purpose. Great. Okay, Christine, how about the advantages you find in being in an alternative practice of law?
Well, the big one is one that everyone else has already talked about, which is the no billable hours. And you know, I'm the only timekeeping that I do is because I'm the AB 1058 commissioner. And so if I do something that's not directly reimbursed by the grant, I do have to write down point 2, reviewed a domestic violence restraining order and issued a TRO. But that's really the only timekeeping that I have to do. The other good part is I don't have to worry about collections. I don't have to have those awkward meetings once a month with your fiscal manager in terms of why your clients aren't paying your bills. So that's most of the time they did, but there were sometimes awkward conversations about certain clients about, you know, why they weren't paying the bills and are they unhappy. And so then you have to have an equally awkward conversation about, well, it's their case is not going the way that they had hoped. And so that can result in some fiscal consequences for the firm. Other advantages is that I don't have to worry about clients. In terms of the normal working hours, I have probably a more normal schedule than I did when I was working as a research attorney, or actually probably about the same. I had an absolutely insane schedule when I was in private practice. I think others have alluded to it, but it was not uncommon for me to be putting in 12 or 14-hour days as an associate because of all the work that needed to get done. One thing that hasn't been touched on that haven't heard so far is that government attorneys don't make as much as those that are in private practice, but there are a lot of other more tangible benefits. Fantastic retirement plans, great health insurance benefits. So those are, I can't speak to ADR and to Robert Half in terms of what they offer, but that's certainly a really big plus from where I was. I think one thing that's really, really big for me, Matt alluded to it, is public service. That's a really big thing for me. The fact that in my daily calendars, it's not at all unusual for me to have a wide variety from the socioeconomic spectrum. One calendar in particular was memorable because I had, like a third or fourth case in was a person who was homeless and living in their car and trying to figure out how they were going to put food on the table. And then 3 or 4 cases later were a couple that were each very, very high income earners who were just arguing over which polo camp the kids should be attending. Should it be this polo camp over here or this polo camp over there? And I think it really helps you with perspective and kind of trying to understand sociology and psychology. I'm not putting it well, but to me, it's interesting that they're all in my court for the same reason. And they all have the same needs, but they're coming from very different perspectives. So it allows me to understand and work better, I think, with the public and to try to give them what they need to understand that what the public's justice system can do for them. I think the other thing that really, really helps, that I really enjoy, is that it's going to sound trite, but it's true. I learn something new every single day. There isn't a day that goes by that I don't learn a new case, learn a new nuance, learn something new about myself, learn something new about how to handle a case as a judicial officer, where I feel like I grow as a judicial officer. And that I think is just wonderful that I'm able to do that. I really do. I'm grateful that I did litigation. It gave me a really good foundational base, but I don't miss it. And I'm happy to be where I am.
Oh, that is outstanding. And wow, what a great story having to do with seeing different perspectives, and I think especially now it's so important to recognize that people are coming from different places. And I'm so glad you're in that role and that you care about people. So we'll stay with you. And we'll go back in the opposite order. And so now the flip side of the question. So what challenges do you see in your alternative practice of law that maybe wasn't there in the traditional attorney role? So
there's a couple of big ones. Okay. One is that I alluded to it earlier, is that government work doesn't normally pay as well. And I'm in a different situation, but a lot of people, if you want to come on board as a research attorney, you probably, if you have enough experience to really be effective as a research attorney, you're probably going to earn more in the private sector than you would working for government. And I think, Matt, I'm seeing nodding your head, so it sounds like a general agreement. The other thing too is that there's no such thing as a bonus in government work. So it doesn't matter how hard you work, either your pay is the same. Speaking of pay, there's always the Damocles sword of budget cuts, and they're the courts are government agencies. We had a pretty big blow to our budget, just like every court did, and trying to figure out how to do the same or do more with less. Having to do with furloughs. I went through, a couple of rounds of furloughs when I was at Solano Superior. And so we all had to do, so that's always a reality that we have to face. In terms of my role as a commissioner, there's a couple of things. One is I don't know that people know that it can be lonely, because judicial officers have to maintain a certain professional distance from the bar. We can't have the friendly banter relationship. I mean, there's some of that, but we have to be much more guarded. We have to be much more careful about what we say and who we say it to, because a wrong turn of phrase can land us in front of the Commission on Judicial Performance, which is where you do not want to be. So because of that, your social relationships are more limited. So you're limited to your colleagues within your court and with other courts. And so that's something that I think a lot of people maybe are not prepared for. There's, as I alluded to, the different relationship with the bar. And so I think that's one thing. In terms of being a commissioner, I'm going to let everyone in a little bit of a secret. It's not true in Contra Costa, but there are some courts where the judiciary emphasizes the word subordinate in subordinate judicial officer. So commissioners are treated as slightly less than. You're judicial officers, but you're not full-fledged judges. And there are some courts where the culture is to remind the commissioners of that. So that's a not very pleasant part of the job. Again, it's not true in Contra Costa. I've been very, very pleasantly welcomed into the fold, if you will, as a judicial officer, which I think is wonderful. But for those who are considering this career path of being a commissioner, it's just something to be aware of.
Wow. Thank you. I had not thought about the loneliness factor and how really by necessity the relationships do change.
They do.
So yeah, thank you for sharing that. Great. Okay, so Juliet, did you have a long list of disadvantages?
I don't. I have a couple.
Not disadvantages, challenges.
Well, I think some of the disadvantage, and this would be more coming from being an educator and then moving to in-house. And Mark talked about it too. When you're teaching, and I in particular was really challenged by this because I was teaching a lot of our technology classes like e-discovery, as you all know, Kate, and all of these areas that are evolving. And so, and trial presentation, those sorts of software programs are changing and new ones are coming out all the time. And so having to stay on top of things was a requirement when I was an educator. And that is not really, the world of contracts is not one that's ever changing. It doesn't seem like. Obviously, there's been a lot of issues with COVID. And so that's been exciting, not exciting for COVID, but exciting for learning how to protect our employees in a time like this and to do it in our contracts. So I would say there's a little bit of a chance of stagnating more when you're in-house, at least where I'm working, because there's not as much of a need to stay on top of all of the developments in the law. And then again, I mean, it's just the not being around more people who are your people. So it kind of, it cuts both ways. It's nice to be around non-lawyers, but it's also nice when you can really just have the type of conversations that you need to have. And sometimes it's something about the law that wouldn't interest anybody. So.
Good. Very good insights. How about you, Mark? What challenges do you see in your
Well,
alternate
to channeling Juliet a little bit, I miss the part of being in-house and being in a law firm, of having like a team that I was able to assemble, and just the day-to-day interactions. That's not part of my world these days. The biggest challenges are mediations are typically high stress events. People are coming to you typically because they can't solve their problems themselves. They need help. And so there's the stress, and it's not just the client stress, it's the lawyer stress too. But if you can help them through it, it's a very rewarding feeling. So that's part of it. The other part of it is, I am a firm believer that the merits of every dispute is very important, but it's often not the key to unlocking the dispute in terms of why it hasn't resolved so far. So the lawyers do a very good job on average of summarizing their legal positions and the facts that support their position when they send their briefs to me. But often there's a whole dynamic going on in the background involving people and organizations, lawyers, clients, in-house groups, insurance companies. And rarely do people say, by the way, here's the problem we're going to be dealing with. So part of my job is to figure out the often more than one type of issues that are floating around in the background to unlock sort of a path. Somebody asked me sort of, how do you analogize the work you do? And I said, well, if I'm doing it really well, my best analogy is a lifeguard. And my job is to save everybody, not just the clients, but the lawyers too, from difficult conversations sometimes about, if Mark thought this case is only worth this, or it should have been settled a long time ago, what's going on with you? And so I have to manage that too. I'm very, very careful working with a great, great group of lawyers, but it's a delicate balance that you have to get through. But the good news is, for me and like people that deal with disputes for extended periods of time, like I used to, would run for weeks or months or years, it's typically a short burst. It's a very intense short burst often. But then you go on to the next thing, or take the break, or like Juliet said, actually take a vacation.
That's great. I love the lifeguard analogy. That seems to be spot on. So thank you for saving lives. How about you, Matt? What challenges do you see in the alternative? I know it's been a short period of time, but
there have been plenty of challenges. Don't worry.
Okay.
No. I have joked. You know, I came to the court as a research attorney, and what I do now is not exactly that. So one of the challenges I've had is sort of the pull that got me here in the first place is not necessarily what I'm doing every day. And that's actually turned out to be good, because the position I'm in now has kind of reactivated the I mean, not the litigator in me per se, because it's a little bit different, but that side of it a little more than a legal research attorney did, because that was purely adjudicatory. But that has been a challenge, because I picked coming to the court for a slightly different reason, and then through opportunities have now taken something that's different. But it's a challenge, but it's not bad, if that makes sense. In my role, one thing that can be a challenge is lots of different people want advice from me. And, you know, technically the way we have it set up in California is the presiding judge essentially runs the court administratively with the assistance of an executive officer. But I also, you know, I'm a lawyer. I don't say no to a judicial officer who asks me a question either. So, you know, there can be some tension there at times, but it's rare. The public information officer aspect is new, challenging, requires a level of patience that I think has helped me grow, but that I certainly didn't have when I started. And so I again, I look at it as a positive as well as a challenge. I mentioned in the advantages, I mentioned this that might be a disadvantage too, is the chaos of what I do. There's just an element of that to it. And I learned to just accept that was how it was going to be. The standards by which I judged performance in my prior life do not apply necessarily, because there was a certain order to things. Even in the chaos of litigation, there was a certain order to things that I don't have necessarily in this position. Then I will say, getting specific, and this goes to what Commissioner Donovan had said earlier, kind of about the payment, the relative pay and the resources, particularly now of the court. I operate as chief counsel, but it's not as if I have, you know, a lot of administrative staff to help me with things. I do all of my own stuff, which I didn't do in a private firm. You know, I had certain people to help me with administrative tasks. I do all of that on my own now, in part because the two people we have designed to do that also, like me, have a number of different jobs, and we just don't. So I have to work that into my day. And then the last thing I'll say is, I found challenging how hard it is to administer a superior court in any respect. I mean, it is just challenging, and I had no idea, no idea walking in. We all kind of knew, how they run. They have an administrative office, okay, but when you see the pressures that are put on and the resource drain that comes, I have never seen people work as hard as I did the court staff work during COVID times, as one example. And that's, again, not a negative, because that's a team coming together. But yeah, I mean, I think that was, those are sort of the challenges I see.
Yeah, thank you for sharing those. I would not have imagined. Yes.
I just want to jump in. on something Matt said.
Absolutely.
Is that I wish that there was a more transparent window into all the work that goes into administering a court. I know how hard Matt works. I know how hard everybody at the court works, and it's just one court. Imagine that multiplied by 58, because we have 58 counties where there's this stereotype of government people who clock in at 10, they take 2 hours for lunch, and then they leave at 2, and nothing gets done, and that could not be further from the truth. And so I appreciate Matt saying what he said, so that perhaps there's a better understanding of just how much work goes into running a court.
Thank you. That was very valuable input. And I have to say that in planning this panel, so Matt, I had not met you before, and you came highly recommended and said, he's a busy guy, but he will do this, right? And Commissioner Donovan, I was not surprised that you answered the invitation in the affirmative, and it really, and you are both, you're both employees of the court, and here you are giving of your evening time as well. And so, and I do thank all the panelists that, given that input that you just both gave to us about court employees, I just really want to affirm you for how much you are giving to the community.
Thank you.
Yeah, appreciate it. Okay, so Matt, we're going to stick with you. And now, what practical advice would you give to someone who's in the traditional lawyer role, who might be looking to enter the alternative law practice to get away from those billable hours?
I can kind of put that into categories of things I wish I'd done and things that I did do. One of the things I wish I'd done is talk to people who are in the areas that I think I'm interested in a lot more, through opportunities like meeting different people in different careers through bar associations and things like that. I could have engaged that, I think, a little bit earlier, and I could have engaged it with more fervor than I did. I ended up okay because an opportunity presented itself, but I think that if I'd been more open to that earlier in my career, I'm not saying things were going to be better or worse or whatever. I'm just saying I think that was an opportunity I could have explored a little bit more. From my experience, I hate the term side hustle, so I will only use it there. But that is one of the ways I got to do what I'm doing right now. Is I took a not even part-time, like a contract job that only sometimes would be as little as 5 to 10 hours a week, but that allowed me to start working with the court. When there was no full-time position, and for my own personal reasons with starting up at a new firm, I wasn't going to go full time. It ended up being a good thing. And so I would encourage people to look for those kinds of opportunities, even, you know, for people who are considering ADR, for example. We have volunteer programs, discovery facilitators with the court, the temporary judge program I mentioned earlier. Those opportunities are out there, which will allow you to explore that area that you think you're interested in without a full-time commitment or some major change of job or some life change. It will require a little extra effort, but you know, that's how good things happen, right? We do in Contra Costa have a lot of those kinds of opportunities, so I'd encourage people to take a look at those. And then the last thing I'll say is, and this was another one that was harder for me, is divorce yourself from the standard expectations of what people might say success is or what you should be doing, right? I don't want to speak for other people if they did or didn't. I sort of had a pre-programmed idea of what I would do as a lawyer, and it would be this step and this step and this step and this step. And I think that once I let go of that, and I took the risk to kind of try something different, that was when it really kind of opened up for me. Some of that might be coincidence of timing. There's a little luck involved in everything, right? But you can also sometimes create your opportunities by loosening up your own expectations of where you should be, and look instead for what you think might make you happy in what you're doing, and allow you to explore the reason you think you might want some alternative career.
Excellent, good advice. Thank you. So Mark, what advice would you give?
Well, I'll build off of Matt's comments. I think being open to new ideas is really important. As I mentioned briefly earlier, I had no plans of being a mediator. I had no plans of being a general counsel. But when the opportunities were presented, I looked at them. Had it not been the company I first went to, Dryers Ice Cream, and you would ask me 2 years before that time, would you ever go work in-house? I'd say, no way, why would I do that? This is fun what I'm doing. And I'd also work with some in-house groups that we're not having a lot of fun on a day-to-day basis. I won't identify them, but you know the companies. But opportunities come up, and it's really important to listen and consider them. That doesn't mean say yes to everything, but really be open-minded, learn additional skill sets. As I mentioned earlier, my training and work as a mediator transformed how I dealt with disputes in my other life. And so be open to those ideas. Roughly the time I was being approached by Dryers, I actually was being recruited by large law firms that wanted me to run their IP antitrust practices. And I was thinking about doing it. I got really close, was flying around the country to meet different people, and they were making offers. And I went home and I was discussing it with my wife, and she's much smarter than I am. Fortunately, she can't hear me. But she just reduced it down immediately by saying, but what is it you like to do? And I realized there were dangling a lot of things, you know, money, position, all that other cool stuff. But what I really liked was working with these people at Dryers, because it was fun, it was exciting. And so fortunately, it all kind of came together. But trust what you really like to do. I don't want to be glib about this. The money takes care of itself, though, I think. But there isn't enough money to pay you to do something you really don't like for a long period of time.
Agreed. Very good advice. Thank you, Mark. Juliet, what advice do you have?
I think in addition to a lot of the really good advice that's already been offered, I would say to take the time, even when you're in a billing job, and it seems like every minute that you are billing or doing anything away from your family is just, you know, it's just sucking the life out of you. Take the time to make relationships with people. And folks told me when I was a new law school graduate that it's not necessarily the partners. Obviously, you want to make a good impression and do a good job, but it's your peers. And it's going to be as you get experience that your peers are also moving up the ladder wherever they end up. And there are, you know, there's a lot of turnover And so as, you know, Archer went bankrupt, I wasn't there when the law firm went bankrupt, but that resulted in a huge dispersal of all of the people who I knew. And that's what led me to be at Robert Half, was a couple of those folks found their way there. But when you take the time to connect with people, not only at you know, at your law firm, but with the Bar Association. When I was working at John F. Kennedy University, I was on the board of the litigation section, and really enjoyed getting to connect with those folks who were from different law firms in the Contra Costa County area, and learning about what the bar does. So finding ways to connect with people is not a short-term plan. It's kind of your long-term way to not only humanize the experience of being a lawyer, because you can hear from people who have maybe survived things that you think you might not make your way out of, but also to help yourself in the long run to get the true behind the scenes story about what it's like where people end up. And that literally from, you know, I got the job at Archer because I connected with someone who went to my law school. And from there, every other step I've taken has been because of the connections that I made with people while working there. And it was not a plan. It was never anything that was fake. I mean, all of us can tell when someone is just wanting to be friends with you. I would think especially people at the court and mediation, you know when it's sincere. And I think having that be part of the positive experience that you have, it'll not only help your own kind of mindset in the short term, but in the long term, those relationships are key to being able to move in-house. And for me, my interview process was just to have an interview. The people who I knew who were already working at the company, their word was enough, I think, to not only get the interview, but to have it be sort of like oh, we just want to make sure that you're going to fit in with our corporate culture. I didn't get asked any of the questions about, you know, contracts and indemnity or any of those things that some people had told me that they had been asked. So I think these relationships will help you, and I think building them from the beginning is a great short and long-term plan.
Excellent. And I'm sensing a common thread with all four of you, and that is it is something that I genuinely believe is that our legal community is actually quite small, and your name, your reputation within the community, how you conduct yourself, I mean, from your first day of class, how you treat your professors, how you treat your fellow students, that continues with you, and whatever reputation you end up building for yourself has ripple effects. And I can see in all four of you that, you know, without, you know, with no eye toward the future of landing the jobs that you have now, you are already building a foundation that supports you in along the pathway and in the job that you are now. That's very encouraging. So Commissioner Donovan, what advice would you give to those in the traditional role who are seeking out?
I would echo what the others have said in terms of building networks. I think that's really, really critical. To add to that, I would add talking to the people who are currently in those roles. So people who are currently doing the job, get a sense from them. Like, for example, if your dream job is to become a research attorney, like Matt currently is and I was, talk to somebody who's in that role. Do they like it? What do they like about it? What do they not like about it? How did they get there? I will tell you that there are very, very few family law research attorney positions in trial courts. There's just not that many of them. But they do exist. You just have, you can find them by talking with other people. You have classmates, you have friends, there's the theory of 6 degrees of separation. The chances are you might not know somebody, but you know somebody who probably knows somebody who probably knows somebody who's in that role. And so that's why it's, I think, really critical to develop those networks and maintain them. I think in terms of other things that I would say, practical advice is, one, don't hesitate to take risks. Apply for positions when they open up. If you have in your head, this is my dream job, whatever your job is, that's X, whatever it is, and a position that seems pretty close to X opens up, go for it. The worst that can happen is that you're number 2 or below on the candidate list, but at least you've tried. You could be number 1, you never know. You just don't know what you're up. Don't talk yourself out of the opportunity. Go for it, try it. I didn't get hired as a research attorney on my first try. It took multiple tries, and I took a risk of applying for a civil research attorney job and at a different county. And I knew halfway through the job interview that it wasn't going to work. It wasn't a good fit. And because I think it was a question about summary judgment motions, which don't exist in family law. So I was caught completely flat-footed on the question because I couldn't answer it. I had no practical experience with it. But it taught me valuable things in terms, gave me practice interviewing, and it showed me this is not the particular avenue for you, but maybe something close to it is what would work. So I would say that. Speaking of positions that are not right, I would say to people, trust your gut if you're applying for a job. If something doesn't feel quite right, like it's not resonating with you, pay attention to that. Again, that's what happened with the job that I applied for the civil research attorney. There was another position, it was actually a commissioner position I applied for several years ago, where I just got the sense that this wasn't a good fit for me. I ended up horribly self-sabotaging the interview. So, my little confession. But just recognize that not every position that sounds great is actually a good fit for you, and don't be afraid to recognize that, to listen to your gut and your intuition. But just take risks, go out there, try it. The worst that somebody can say is no, but at least you've got the experience. So try it.
Outstanding advice from all of you. So I think we're coming to the end of our presentation, but David Pearson, do we have any questions from our attendees? I don't want to ignore any of them. Oh, hello, David.
Hello, I'm hiding in the background. Have not seen any come through from anybody, so if anyone has any, now would be the time to type them into chat. Otherwise, you've been going for almost an hour 40, so you're probably all getting tired.
Wow, yeah. Well, so while we're waiting for maybe any chat to come on, could you each, in closing, because we got this great question from Mark, if you could give one piece of great advice that you received along your career path, and that will give people time to put a question in the chat, and then we can be done. So Commissioner Donovan, we'll start back with you again. Any great advice you received along the way?
I got 2 pieces that were kind of interlinked. One is keep trying.
Okay.
And the other one that I got is that there's no such thing as a wasted opportunity. So even if you end up being in a job for a particular period of time that's not resonating with you, you will pick up skills and knowledge and experience with that job that will serve you in another position. There's no wasted opportunities. There's no wasted knowledge. There's no wasted experience. So everything that you do builds on each other. And and that helped me when I was at a point in my career when I was really frustrated. I felt like I was banging my head against the ceiling. And I was like, here's where I want to go, but I just can't see my way how to do it. Somebody reminded me of that. And that is, I thought, was incredibly helpful advice.
Excellent. Thank you. Juliet, do you have a quick piece of advice that you received along the way that you want to share?
I think the best advice, and I was just sharing it with my my 10-year-old this morning, was just because someone has been practicing longer than you have, don't assume that they're a better lawyer than you are. When I was a brand new lawyer going to you know, an injunction hearing far, far away. And I was getting kind of prepped by the partner that I was working with. He said, well, just how are you feeling about it? And I'm like, well, the person I'm dealing with on the other side is a partner. They've been a partner at their law firm for X number of years. And he just said, just because you are newer doesn't mean that you're not as good a lawyer, that you don't have the capability of arguing this motion. And remember that we all hear our own kind of internal insecurity dialogue. And we just assume maybe that other people don't have that. And I think we're just remembering that even though everyone else might seem to be completely confident and capable of doing everything that they take on, everyone has insecurities. And I think, you know, the advice that we've gotten here about asking someone who's in the position, I think it was you, Commissioner Donovan, that suggested that. Everybody has been there. So if you get a cold call, I mean, when I was looking for jobs, I was cold calling people at firms and just asking them about their experience. We all like to talk. I mean, we've been doing it for, what did you say? 2 hours almost. So I think reach out to people, be willing to kind of be humble in that way, and learn, and also realize that the years of practice don't necessarily equate to skill.
That's very encouraging to me, like right now. Mark, do you have a quick piece of advice that you received along the way that you want to share?
I'm going to quickly just to reiterate one thing. I'm fortunate in my mediations to have people show up where there might be 2 or 3 or more people on one side of the matter. And there's younger people and older people. And I spend a lot of time talking to the younger people who are sometimes, I think, reticent to speak out loud because they think their role is more junior. But gosh, a lot of the times those are the people that have done the real work, understand the matter even better than the senior people that are there. And everybody has great ideas. So I just second the point about engage, engage, engage. And then my last one is, this may be stealing somebody else's earlier point. I had a partner a long time ago who said, carve out a certain amount of time every week, no matter how busy you are, to do something for somebody else with no expectation of getting anything back. It's never about, I'll do this for something back. And I know it sounds a little bit off subject, but it's really been a huge part of my life, because it's so easy to get so absorbed by whatever you're doing to say, I can't do this, I can't do that, I can't make the time. So don't do it because you're going to get a job offer out of it, but it will inure to your benefit over the long haul and make you feel better about yourself.
Great, thank you, Mark. Okay, Matt, quick piece of advice that you got along the way?
Sure, I'll keep it to the 2 things. I thought of 2 things. There's whatever you want to do. There's one, no set path to get there, in the sense of, and this goes back to what Commissioner Donovan said about there's no bad opportunity in that regard. You may not take the exact route that you planned, but whatever you want to do, there isn't necessarily a point A to point B path to go to get there. And so it's okay if you feel like you're wandering a little bit. And whatever you want to do, it's never too late to do it. And those were combined in a probably whoever the person who said it to me probably said it with a little more artfully than I just did. But the idea being that and I know this has happened to me. You get into a position where you think, okay, well, I want to do X, but I can't do that now because of Y and Z, and it's just not. It don't let that hold you back. That's all I can say.
Excellent, thank you. So thank you, panelists. This was fascinating, and I really appreciate all of you giving your time. David, do you want to close us out?
Sure, just make me pop back on the video. Thank you to everybody for our attendees. I put in the chat, the Bar Association should be sending out all of the paperwork, so you will get your MCLE credit, and the panelists have put together some materials that will be emailed out with that as well. And thank you to all the panelists. You did a great job tonight, and you definitely spoke quite a bit. So thank you for volunteering to help the Bar Association tonight and to help all of our members. So thank you, and I hope to see a few of you in court occasionally if we're ever allowed back in the doors.
Thank you, Kate, for your great